Hi there, I'm Jack Price. I teach civil procedure at University of Richmond School of Law. My task in the next couple minutes is to help you tackle a personal jurisdiction question. All right, personal jurisdiction may have taken up many weeks in your first year of law school. It will not take that long for me to explain the key points for tackling a question. One thing to remember in personal jurisdiction, just conceptually, is what it's about. Personal jurisdiction is whether or not the court can tell somebody, a person or entity, a corporation perhaps, what to do. Is somebody subject to this judge who wants to tell him or her what to do? That's all personal jurisdiction is. So when you're in the federal system, federal courts, what powers do they have? Well, Congress could have given the federal courts to tell anyone subject to American jurisdiction what to do. If you are from a foreign country but you land in the United States and you commit some harm, well, guess what? You're in American territory. American government can tell you what to do, including federal judges. Congress didn't take that path. It, in very narrow circumstances, allowed that to happen. But in 99% of the cases that are litigated, Congress chose a different path. They said, why don't we do this? Why don't we tell our federal judges to just pretend that they are state judges when it comes to personal jurisdiction? We said, well, what does that mean? The federal judges will just apply the personal jurisdiction law of state courts. Well, what's the personal jurisdiction law of state courts? How's that any different? Well, states are separate sovereigns. Someone from Oklahoma, an Oklahoma official, be it a judge or the governor, does not have the authority to tell anyone from Kansas how to behave. That judge or governor has to stick to Oklahoma. They've got power over Oklahomans. They don't have power over Kansans. So states have their own laws that dictate to their own courts how their judges are allowed to resolve disputes. And Congress, instead of writing a whole big set of its own laws on how federal judges can exert their authority over people, simply said, why don't you just follow state law? So if you're a federal judge and someone walks into your courtroom and sues somebody, you say to that person, who's the defendant? They explain the defendant to you. You go to the wall and you grab a book. You don't grab your federal rules. You don't grab the constitutional rights of anyone at that point. You grab your state law book. If you're in Oklahoma, you grab the Oklahoma statute book. You're in federal court, but Congress told you, look to the state statutes. So you open that up, and it'll have a list in there that says the judges of Oklahoma, not federal judges, the state judges of Oklahoma may assert jurisdiction, or rather have the power to tell the following people what to do. You can tell people what to do if they're a resident of Oklahoma. You can tell people what to do if they cause harm in Oklahoma, blah, 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 blah. We'll get through some of these examples. But the first thing the judge does, looking at that state book, figures out whether or not state law authorizes a state judge to exercise personal jurisdiction over the defendant. If it does, then the federal judge says, okay, great. I will go ahead and follow that unless, and this is what most of you learned in first year civil procedure, unless that state law violates the Constitution. So what's that mean? This is International Shoe and Helicopteros and Burger King. Do you remember any of that stuff? Listen, it's okay if you do. It's okay if you don't, because I'm going to summarize it for you right now. The federal judge reads through his list from the Oklahoma state statute and says, okay, it says here I can assert jurisdiction, but I want to make sure that jurisdiction is constitutional. So then the judge goes back and gets his Constitution book. Let's presume, strangely enough, there's a single book that tells it all very clearly. If there was, that book would say this: judge, any state statute with regard to personal jurisdiction is constitutional if it says that if you are asserting jurisdiction over a resident of a state, if that defendant has consented to jurisdiction, if that defendant has been served with process in the state, if that defendant has minimum contacts with the state that gave rise to the lawsuit, or if that defendant is doing substantial business in the state. Okay, those five grounds are all instances or cover the map of when personal jurisdiction is constitutional. So state law says you can do it in this instance, and then the judge says, okay, great. That instance works as long as it counts as either residency, consent, service, minimum contacts, or substantial business. I have a mnemonic I use all the time for this. Personal jurisdiction rarely causes severe mental strain. RCSMN. Personal jurisdiction rarely causes severe mental strain. Maybe just remember the words instead of the mnemonic, right? Okay, so let's go through each of these quickly. Residency just means you live in the state. Nothing more complicated. It's the same rule for citizenship as we saw in diversity jurisdiction, or you may have learned before in diversity jurisdiction for federal courts. Do you live there and intend to remain? Corporations, where's your nerve center, and what states are you incorporated in? Consent. Consent is simply whether or not the defendant decides, well, you know what, maybe I'm not subject to the authority, but I'm willing to submit to it. I'm not required to, but if I'm willing to, maybe I will. Maybe I'll consent to the court's jurisdiction because I want to file a counterclaim, which I think is worth a lot more money than the plaintiff's claim. Okay, so consent works well as well. Service. Service is an old-fashioned rule. It simply says, if the defendant is inside the state where you want to file suit, and you serve process on that defendant, which is simply handing the defendant a copy of the complaint and a summons, a government document saying, please come talk to us, you are getting sued. If you hand those papers to the defendant, when the defendant is inside the state, that amounts to personal jurisdiction at that moment. It tags the defendant, subjects him or her to the power of the court. Minimum contacts. All right, so this is what you may have spent a lot of time figuring out in first-year civil procedure. I will boil it down to 2 words. I'm slimming it maybe a little bit too much, but if you remember these, you're in great shape. Purposeful availment. Purposeful being even the most important part of those 2 words. Purposeful. A minimum contact is a contact that somebody intentionally establishes with a particular state. I decide to drive to Oklahoma. That's an intentional decision, right? If something bad happens there, I have made contacts with that state. Okay. Now compare that to if I put something in the world of commerce. I loan you my car and you drive wherever you want to drive. I neglect to tell you the brakes are poor and you get into a car accident, but you do so in Wyoming. Someone wants to sue me for maintaining a dangerous car in Wyoming. I didn't intentionally establish any contacts with Wyoming. No way. I didn't do that. So purposeful or intentional is key. The other thing that's key to minimum contacts is those contacts have to give rise to the lawsuit. Listen, after the bar exam is over, you may travel the world over. You may go to every state in the union. You will have therefore established contacts with every state in the union. Does that mean you can get sued in every state in the union? No. Because those contacts, though you have them, will presumably not all or individually give rise to any particular lawsuit. Now, if you go down to Louisiana for Mardi Gras after the bar exam and you get into trouble there, those contacts will have given rise to the lawsuit, but not otherwise. Finally, substantial business. This is narrow. Sometimes the court calls it general jurisdiction. What they mean there is simply this. When a company, it's not a person, it won't work for people, when a company is so well established and heavily established, employing thousands of people in the same state, that place is essentially their home, then we will call them a resident. In other words, doing substantial business in a particular place amounts to residency. It's not technically residency because it's not where they're headquartered, where their nerve center is, or where they're or where they are incorporated. But it amounts to, it's functionally identical to residency. Okay, so a very quick review. Personal jurisdiction, it's the authority of a federal judge to tell somebody what to do. The federal judge opens his state law book and says, is this covered by state law? Is it? Great. Then I go to my federal law book. The federal law book says, as long as the person is a resident, consents, has been served in the state, has minimum contacts with the state that give rise to the lawsuit, or is doing substantial business, then it's constitutional, and the judge begins adjudicating the lawsuit. That's how to tackle a personal jurisdiction question. Good luck to you.